You ready? All right. We'll order the October 25th, 2023 meeting of the Law Committee. Take the roll, please.
Sure, Mr. Chairman. Pulaski, Cunningham, Peter, and Whalen are excused this evening. Burgdorf?
Here.
Meany?
Here.
Kuhn?
Here.
Mayo?
Here.
Ricard?
Present.
Okay. First thing we need to do is approve the previous minutes. Can I get a motion?
So moved.
Second, Mr. Mayo. All in favor?
Aye.
Okay. Yeah.
Okay. Items 2, 3, 4, and 5 are tabled at request of sponsor. Item 8 and 9 are tabled at request of sponsor. And item 7 will be tabled pending public hearing. Moving to item 6, local law I, a local law of the County of Albany, New York, establishing chapter 225 of the Albany County Code, setting forth requirements for resettlement disclosure in Albany County.
Mr. Burgdorf?
Okay, I wish I could play the tape from last night at Social Services, but we sent everybody a sort of a detail sheet of the changes that we had made to the bill. I said last night we did what people in sports do. You go to the tape, you take everybody's comments, and you try to resolve them, which we felt we had done. We asked council, majority council, if they had any comments, and then there was a Zoom meeting with majority council where Pat Narnis went through our proposed changes and to see if there were any additional comments, which, so here we are. So we then made those changes, we put them into both social services and this committee thing. Social Services passed it out unanimously last night with no comments. So what we did was, we also, I should say, that Arnis met with at least one member of your delegation. Allison called me. She was very sensitive to the way children were treated in this. So we took children and their ages out completely. She was also concerned that she didn't want a facility to have to send a notice to a whole bunch of different places. So we changed it so that the facility would actually have to send one notice to the county clerk, who would then make whatever notices there were within the county to the county executive, to the chair, to the majority leader, minority leader, legislator, and any affected municipalities. So we made that change as well. We deleted all the references to homeless persons, migrants, or asylum seekers, and revised it to expand the concept to all persons from foreign municipalities. So it's not a question of who you are. You're not discriminating against any group of people, but we actually set a new standard that the notification would be, and people were worried about, what if the Association of Counties had a meeting and they booked 50 rooms for a week and there were kids involved, would they have to? No. We set a standard that you would have to book at least 20 rooms for a minimum of 30 days. So it is really just long-term foreign municipality notice would be required of the venue. We changed the definition of foreign municipality. It's modified to indicate only municipalities outside of Albany County would be included, as well as those exempted by reasons of contracts with the county. Like, for example, if Rensselaer County or Greene County had contracts with us for Raise the Age, where they were coming into Albany County, those obviously would be exempted. So any county that had an official agreement with Albany County would not be included. Because people were concerned about how this would apply to inter-county transfers. We changed the definition of venue to exempt not-for-profits, so that if Equinox is running a program for domestic women, domestically abused women, that would not be subject to it. The best way that I can give an example of this is if the Red Cross did something philanthropically for 30 rooms for 2 months, and it was for the Red Cross, they would be exempt. But if the Red Cross was doing it as an agent for New York City, they would not be exempt. So it makes that distinction, that only a not-for-profit if, excuse me, did somebody say something over there? I thought I heard a comment. No. Oh, okay. And additionally, throughout the law, proprietor was changed to just limit responsible parties. We also made changes that there must be a signed contract to trigger the legislation. Once again, 20 rooms for 30 days. Once again, the exclusion for municipal associations or counties that have contracts. The notice of the contract, instead of the venue having to notify, if it were in the city of Albany, the mayor, all the city council people, the county executive, the county legislator, it's just the county clerk, and we Arnis talked to the county clerk and provided him with a copy of the legislation. Once again, we removed the requirement for the number of persons, number of children, and intended lengths of stay to be reported. Instead, the requirement that if that information only if it were known. We removed ages of children out of respect for certain members which had increased sensitivity for that particular area. So we made, like I said, we went to the tapes. We addressed virtually every comment that was made, and we reached out to see if there were additional comments, and hearing none, this is what we have before us. And with that, with the help of my counsel, would be delighted to answer any questions that you might have.
Okay, thank you. Anybody? Yeah.
Yeah, I appreciate that that an effort has been made to improve or to address some of the comments that have been made over the last few meetings about this. And I've thought long and hard about this, and also done some of my own kind of independent research on this. Here is where I still find myself on this, though. This, to me, still seems like, and I don't think this can necessarily be resolved by tweaking the language, a solution sort of in search of a problem. There is no indication that I've seen, no evidence that I've seen, that the governmental agencies that have to deliver services to the people that this is addressing have any need or any demand for the owners of hotels or other venues to be providing them this information. The most, in theory, impacted governmental entities, I think, would be the school districts. And from everything that I've heard, and people I've spoken to over the last month, the school districts are not demanding this at all. That they are not, that there's no sort of hue and cry from the school districts, we need the hotels to tell us about this. It sounds like they are dealing with this and it's fine. To the extent that there are people who, under the scenarios that are described here, are putting demands on county services, the county will find out about that when the requests for services are made by whomever, presumably by the people in question. So I'm predisposed against putting new regulatory burdens on hotel owners to provide this information when there doesn't appear to be any demand or necessity for them to do so. Providing this information to the chair of the legislature or to legislators, they don't provide the county services. It is the county executive who obviously runs the executive part of the county. I'm not hearing that there's a real demand there either for this information. So, if there's any individual municipality who feels like they need this information, the individual municipalities are certainly free to the town boards to pass a law along these lines. But I just don't see the need for the county to do it when the entities that would, in theory, benefit from this information aren't demanding it. So because of that, I'm not inclined to support this. And I guess I would move that it be reported out with a negative recommendation. Because for me, I don't like for us to pass ordinances and laws unless there is a real need to do so. And I just haven't seen any evidence of a need. Again, I feel like this is a solution looking for a problem. So for that reason, I'm going to move that it be reported out with a negative
Mr.
recommendation.
Chair, may I respond to that?
Yeah, you can respond. Go ahead.
Well, unfortunately, Jeff, you don't sit where I sit. In our town, in our school district, we haven't had the extended conversations with our school superintendent, who enthusiastically embraced these kids and said, look, we got 24 English as second language teachers. I'm telling you that we can absorb that. But tell me you're going to send me 40 more next year, and the 40 the year after that, I have to know, I have to plan. Those were what our school district said to me. I can tell you what our police chief said to me. Very concerned about the type of people that is coming to this venue now. We have had 5 felony arrests in the period of a week. Rape, robbery, domestic violence, harassment.
But how does this address that? How does this address that at all?
What it does is it tells us that you may be having a transient population coming to your town. You don't have a lot of hotels in your town, so it's probably not an issue for you. 80% of the hotel rooms are in the town of Colony. Okay.
And let me just jump in.
Well, let me
just address that specifically, because I don't disagree with that, and as a matter of fact, so if that's in fact the case, and you're talking about the Colony Police Department, and isn't the ideal governmental entity then who is closest to this issue? It sounds like, by everything you're saying, it's the town of Colony.
No.
So why shouldn't the town of Colony, who's closest to these issues and can tailor whatever it is specifically, why shouldn't they be
Because
addressing?
Albany County has an executive order, which has been renewed every 8 or 15 days, saying there's an emergency in place, and that nobody should come into the county without their permission. That has been continuously violated by the city of New York. And there's litigation about it, statewide. So this is an Albany County issue. And it's an Albany County issue for the hotels that are in Little and the hotels that are in the city of Albany or any place else. So I would beg to differ with you. And I would ask you, send it out with no recommendation. If you want to vote against it, vote against it. But there are other people, you don't get the comments that I get when I go door to door and people say, what's going on? What's going to happen? Are there more people coming? And we say, we don't know.
All right, thank you, Mr. Bergen.
Okay.
You got a motion on the floor, do I have a second?
Are we doing no recommendation or a negative recommendation?
He voted, the motion on the floor is negative.
I'll second
Second. All right, the vote on that, all in favor?
it.
Opposed? Oh, all right, thank you. Comes out with negative recommendation.
So what happens to a...
Wait, Paul.
No, what happens to a local law that came out of one committee without a negative recommendation and another one with the recommendation?
Just gets
They
reported
both
out.
go to the floor.
They go to the floor.
So there's no
And
difference,
then, you know,
technically.
caucus, we tell people that one came out negative, the other one came out with none.
Now,
Do what they-
did everybody vote negative here? I don't.
Yeah,
I'm not on the committee.
he's not on the committee.
I'm a guest.
Yeah, it was 4-1.
Okay.
Thanks.
Item 10 is a local law of the County of Albany, or a public hearing for the local law F, a local law of the County of Albany, New York, amending Chapter 106 of the Albany County Code, setting forth requirements for location of substance abuse treatment facilities within Albany County. Dennis Feeney has been designated the prime sponsor.
Yes, so there's been some significant or enough changes on this to trigger another public hearing. The version's on Granicus, correct?
Yes, and I believe there may be more.
There may be more coming?
It would be not the last item, because local law F is
Oh.
actually earlier in the,
Okay,
yeah,
sorry.
it's Granite-Pittsburgh.
So what we're doing is just trying to pass this out for a new public hearing with changes that have been made. I know if nobody else wants to talk about it, I know Mr. Miller wants to make some comments.
Yep.
Go ahead.
Yeah.
Sure.
So I just have a concern about this. So in honest, I thought Allison would be here too, but, in fairness, when this first came out, I put my name on it as a co-sponsor. It seemed innocuous to me. And we did hear through public hearings some concerns from the field about the bill. And I think those things were very strong arguments. And ultimately, Allison actually turned me on to the mental health law for New York State to say, hey, here's this law that we're looking at that we're trying to address. And that law actually gives us exactly what the law we're trying to pass has in it. So there's the things that the people in the field talked about with the fact that, this is going to slow the process down. It's a little bit of NIMBYism. We don't do this for any other facility. Somebody wants to do an alcoholic treatment facility or, pharmacy, anybody else that's going to do substance abuse, treatment. It's only for this type of facility that we're singling this out, which is a problem. But the other issue is really the New York State mental health law, I think it's 32 that this is, already gives the local government agency, which is our own Department of Mental Health, the right to hold a hearing and to notify people. It hasn't been happening. That's an issue. That's our internal issue. So what I'm seeing is this is a law essentially to enforce a law. And I don't, I'm not a lawyer. You guys that are in this committee can talk about it a little bit better, but I don't see where we need a law to enforce a law that already exists. That's just not being done correctly. So I'd much rather see us work with our own Department of Mental Health, let them know what our expectations are as a legislature in terms of notifications for people, in terms of holding the public hearing they're required to do, and in terms of doing the background kind of work. So it's a little bit on OASIS at the state level. It's on our own Department of Mental Health, because when these operators come in, and this stems from a case in Allison's district in Manans, but we have found out some very disturbing things about that particular place in terms of the operator inexperience, problems in the past, not properly accredited or whatever, that should have been picked up through OASIS, that our own mental health should have addressed, and they didn't. But going forward, again, I just want to make the point to you guys as you think about it. I don't know if there's going to be a vote on it tonight, it's like it's a public hearing. But to me, it's a law to enforce the law we already have, and that we can handle this internally by just setting the expectations as a legislature, through communications with the Department of Mental Health, that we expect the public hearings that are allowed to be held, under law to be held, and that we get notified.
Okay.
That's my 2
Thanks.
cents. Thank you.
This is just a public hearing resolution. Anybody else want to comment, or?
So just procedurally, we pass the public hearing resolution, it goes to public hearing, and then it comes back to us
Yes.
for substantive discussion at some.
Right.
We had one already, right, on this?
Yeah,
And
and
then
then because she's making
revisions?
a lot of changes,
Yes.
it triggered another public hearing.
Gotcha.
So, yeah, after the public hearing, we come back and we talk about it
Do
again.
it again.
You know, if it goes to the floor, we vote on it. Ms. Bergdorf?
Are the changes that were made present anywhere in the
Some
text?
changes are in there. It's my understanding that she may be making further changes in response to legislator comments. So it will be finalized before it goes to public hearing, of course.
So this is another one that we have to vote on without actually seeing the words?
For the
what
public
the
hearing, and
changes
it'll be
are.
voted on at the meeting.
Yeah, it's not, we're not voting on the actual law, we're just voting on another public hearing for it. She's made some changes, she's gonna make more changes, you will see that before the public hearing.
If I could too,
Yeah.
I had the same issue, that's why I want to address it. When I looked at it, and Allison told me she made changes, I didn't see them. In my mind, I was looking for, Paul, I was looking for like cross-outs and stuff, but it's just bracketed. The stuff she's removing are in there, Paul, but they're all bracketed. So if it's bracketed, it's stuff she was taking out.
Well, once again, I don't know where it is.
I don't have my thing.
I don't think it's in the hard copy. so maybe-
No, there are some changes already in there, but like I mentioned, she is
Is
continuously
it
making
in
changes.
Granicus?
Yeah, some changes are in there, but she's making continuous changes now, and she was going to update them. They will be in before the meeting, of course, because it needs to be voted on then. Of course, that will be locked in place for the public hearing.
I don't see it in Granicus. What number is it?
Local law F is number
9.
7.
7?
Local law F itself, the public hearing is 9,
No?
or 10.
Law Committee, Local Law 7 is reporting dates for
Yeah.
financial updates.
Oh, it was in Granicus.
I mean, I don't see how we can vote on this without having some sense as to what the changes are.
Well, there were no changes from the last meeting to what is in Granicus, so you've seen. them.
Well, you said there were changes and there
Well, I
weren't
said she's
Granicus.
making changes further that will be in before the meeting. She has not made changes yet, other, that are reflected in Granicus, except for what was in at the last meeting.
In other words, we're being asked to vote for public hearing on something that we have absolutely no idea what it is and how it relates to the items that were discussed in public hearing, where there were 20 speakers who spoke out, and so we don't even know what we're voting to hold a public hearing on.
Well, in fairness, changes can always be made for public hearings up until the point of publication. So this is not unusual for changes to be made at this stage.
We've done it before.
Oh, I know.
All right, okay. Anyway, can we get a motion?
I'll make a motion.
A second?
Yeah, let me, before we vote, I'll just say that I saw all the same comments that we all saw from a lot of, it seemed like fairly knowledgeable stakeholders about this, who seemed pretty universally opposed. So, I'm gonna vote to report it out, but
This is just for the public hearing, you're not approving.
I know, I'm just putting it on the record, and I know there's gonna be some further changes made to this, and I'll absolutely look at those further changes, but I have making my serious reservations about this public.
Understand. Can we get a vote?
Well, I'm gonna vote against this, and I have never voted against a public hearing. But I'm getting to the point where it's very hard to cast a knowledgeable vote based on the fact that someone's making changes. And obviously the changes are drastic enough, somebody's made the judgment that it has to go back out to public hearing, that the first public hearing wouldn't suffice. So I think, just as a law committee, forget Alice and this bill, this is a terrible precedent to run with. to say, well, we're just gonna report stuff out, and you guys, you know, you don't get to understand it. You don't get to know what it is. And we'll let you know when we go to print with it. That's not really the way an informed legislature works.
Thank you, Paul.
I
Do we have a
appreciate
vote?
that.
All in favor?
Aye.
Opposed? Paul?
Nay.
All right, thank you. Motion to adjourn?
So moved.
Vote. Second, all in favor?
Aye.
Good night.